Welcome to EI Legal's video on unfair dismissal. I'm Patricia Ryan, Practice Manager at EI Legal. In July 2009, the Fair Work Act commenced with some significant changes to the law relating to unfair dismissals. The most important one of these for small businesses is the reinstatement of employees' rights to lodge an unfair dismissal claim, no matter what the size of the employer's business. Previously, only employees in businesses with more than 100 employees could bring a claim. There is still some difference between small and large businesses. A small business employer is defined as a business with fewer than 15 employees. This is calculated by head count, including regular casuals. The Act introduced the concept of a small business fair dismissal code. The code sets out a checklist for small business to follow. Where the code is followed, the dismissal will not be regarded as unfair. Unfair dismissal applications are subject to minimum employment periods. These are 12 months for employees of small business and 6 months for all other employees. What is a dismissal? A dismissal occurs where the employment was terminated at the initiative of the employer, or the employee resigned but was forced to do so by the conduct of the employer. Certain employees are excluded from being able to bring a claim. These are fixed-term employees, apprentices and trainees where the employment ends at the end of the training arrangement, high-income employees, that is, those employees earning over $113,800 per annum and who are not award or agreement covered, or, if award or agreement covered, have a high income guarantee in place. An employee dismissed due to a genuine redundancy will also be exempt. A genuine redundancy is defined as a situation where the employer no longer requires the person's job to be performed by anyone, and the employer has complied with any obligation to consult as required by an award or enterprise agreement. However, it won't be a genuine redundancy if the person could have been redeployed by the employer or within an associated entity. A demotion will not be regarded as a dismissal where the person was demoted to a position that does not involve a significant reduction in his or her remuneration or duties. Claims must be filed within 14 days from the date of dismissal. Extensions can be sought and may be granted in exceptional circumstances. Applications for unfair dismissal are referred to a conciliator. Most conciliations are conducted by telephone. The conciliator will attempt to get the parties to explore all possibilities for settlement. If unsuccessful, the matter will be listed for hearing. In what circumstances is conduct likely to be found to be unjust, harsh or unreasonable? In determining whether the employee's dismissal was harsh, unjust or unreasonable, Fair Work Australia is required to consider the following. First, whether there was a valid reason for the dismissal related to the person's capacity or conduct, and second, whether the person was notified of that reason. Thirdly, whether the person was given an opportunity to respond to any reason related to capacity or conduct of the person. And fourthly, any unreasonable refusal by the employer to allow the person to have a support person present to assist at any discussions relating to dismissal. Fifth, if the dismissal related to unsatisfactory performance by the person, whether the person had been warned about that unsatisfactory performance before the dismissal. Next, the degree to which the size of the employer's enterprise would be likely to impact on the procedures followed in effecting the dismissal. And finally, the degree to which the absence of dedicated human resource management specialists or expertise would be likely to impact on the procedures followed in effecting the dismissal. What outcome can be awarded? The primary remedy is reinstatement, with or without lost pay. The Fair Work Tribunal can also order up to 26 weeks in salary as compensation. In determining amounts for compensation, the following criteria is used. 1. The effect of the order on the viability of the employer's business. 2. The length of service of the employee. 3. The remuneration that would have been earned if not for the dismissal. 4. The person's efforts to mitigate his or her losses. And finally, any other remuneration earned. So what can employers do to avoid claims? It is crucial to understand that dismissals must meet tests of both substantive and procedural fairness. Substantive fairness is about the reason for the decision. Procedural fairness relates to the process involved in the dismissal. Take care to ensure that both the reasons for dismissal are sound and that the process is fair. Ensure the employee is provided with a written letter of termination, setting out clearly the reasons for the dismissal. Carefully consider, if terminating without notice, whether there are grounds for summary dismissal, that is, dismissal without notice. There needs to be serious misconduct such as theft, violence or safety breaches to warrant summary dismissal. Even then, it could be harsh, particularly for long-serving employees with previously good records. If you would like more information on unfair dismissal, or if you have any questions, please contact us on the details provided. Thank you.